Amid all the calls for action on gender-based violence, promises to make it easier for women to report cases of violence against them, the commitments to harsher sentences for violent bullies who attack women. This story is particularly disheartening. It involves some very raw and awful footage of a man repeatedly beating his estranged wife. Now, last year, Nicoline Swartz reported to the police that her ex-husband had attacked her viciously a number of times, sometimes in front of their children. The matter, however, was struck off the court roll. Then AfriForum's private prosecution unit got involved. The matter was re-enrolled. This week the matter was in court. But despite some damning evidence, Yaku Swartz was eventually only fined 20,000 rand. Barry Bateman, who speaks for AfriForum, joins us now. Barry, these videos are awful. Tell me first why this matter was originally struck off the roll in the first place. What did AfriForum do to get it re-enrolled?
Good evening, Sally. We don't actually know the full reason for why the matter was struck off the roll. I think it was the beginning of last year. The matter was investigated, handed over to the NPA. It was enrolled. On the day that the matter was supposed to go on trial, Nicoline Swartz arrived there. She was ready to take the stand, and she was informed by the prosecutor, well, sorry, this matter has been struck off the roll. It was then out of the desperation that she and her family approached the AfriForum's private prosecutions unit. Advocate Gerry Nel consulted extensively with her and prepared representations to the Director of Public Prosecutions in Gauteng. Those representations were made. The DPP, having seen, the amount of evidence, the pretty straightforward case that Yaku Swartz had to face, ordered that the matter be re-enrolled immediately. It was then that the matter we got to, well, yesterday, where the trial was supposed to start.
All right. Now, my understanding is that the footage, and there's a lot of footage, and it's awful, but it was not allowed in court admissible as evidence, and you'll correct me if I'm getting the facts wrong here, but not allowed unless the state was prepared to vouch for its authenticity, and the state wasn't prepared to do that. Am I right, Barry? And if that's indeed the case, how do you know this video footage is authentic, and why do you think the state wouldn't vouch for it?
Well, two things happened during the cross-examination, Sally. Two things happened during the sentencing argument. First, the defense got up, and the defense submitted to the court that Yaku Swartz, his client, was remorseful for his actions, that he was going through various psychological programs and receiving treatment for his anger, and he was on the road to recovery. This was accepted by the court without challenge from the state, despite not a single ounce of evidence being submitted by the defense to prove this. So there was no psychological report, there was nothing. It was simply admitted to the court and accepted because it wasn't challenged. Then the state got up and said they want to, this is an aggravation of sentence, they want to admit the evidence, the surveillance footage that depicts Yaku Swartz, severely assaulting his estranged wife. It was then that the defense got up and said, well, they have questions related to the authenticity of the video evidence. They had issues about the chain of evidence, how it was collected, who it was handled by, and so on. The state then, going to respond to this, well, said, if that's the case, well, they're not going to take it any further. The magistrate had ruled that he's not going to allow the admissibility of this evidence unless the state is going to bring some evidence to prove its authenticity. The state wasn't going to take it any further. Now, this is despite the fact that the video evidence expert was summoned by the state to testify in the trial. Had the trial gone ahead, he was scheduled to testify in that very court today. So it would have just required the prosecutor to postpone the matter for one day so that he could cross-examine or bring this video expert to the stand to authenticate the chain of evidence and the authenticity of this evidence. That's how we know that this video footage is authentic. But beyond that, from a criminal law perspective, Sally, all the prosecutor had to do was to call Nicoline Swartz to the stand. Yesterday, the prosecutor didn't even greet Nicoline Swartz. He had no conversation with her whatsoever. There was no engagement whatsoever from the prosecutor, whom we assume was there to defend the rights of another victim of gender-based violence. So the magistrate ultimately, without having been presented with this extreme videos of the violence that was meted out against Ms. Swart, and then having simply accepted the fact that was put unchallenged to him that Mr. Swart is receiving counselling and on a road to recovery, the magistrate came to what programs such as psychological assessments and the like. Because again, and I'll repeat it, there was no evidence presented to the court to show that he had received any psychological treatment or anything related to anger.
So, Barry, this is all over social media now, but the way you're explaining this case, it sounds like a textbook example of how the state has failed a woman who went to the courts to get protection and who wanted justice. I'm not sure if the prosecutor, in not greeting her, perhaps there was an axe to grind over this issue being re-enrolled. Perhaps you'd have a better understanding of why it was handled in the way it was. But I suppose what I want to know is what is happening next. What is AfriForum going to do? What is the state saying?
Well, you know, I don't need to say that it's a textbook case of a poor handling of a gender-based violence case. We can just take it from the complainant in this matter, Nicolene. She is disappointed at the sentence that was imposed, although she is very happy with the fact that they've got the guilty verdict, that he pleaded guilty. She's not satisfied with the sentence. She wanted to take to the stand. She wanted to testify. She wanted to present this evidence to a court of law to show how she had been attacked. On the next step, Sally, unfortunately, and this is the assessment of Advocate Gerrie Nel, there is no scope here for an appeal, for example. She's got, Nicolene has got the guilty verdict. She's going to take that. You know, in criminal law, and you've possibly heard it over the years, there's very limited scope for the state to appeal a particular matter. It has to be on a particular point of law where, you might believe that there was a misdirection. In this particular event, the state presented its case, as weak as it was in sentencing, and this is what the judge, or the magistrate rather, came to in terms of the imposition of a sentence.
Disappointing indeed. Barry Bateman, thank you very much for chatting to us tonight. Barry Bateman from AfriForum. Let's stay